presentation. But joining us today is Paul Frederick, co-founder of Hospitality Security Advisors, longtime hospitality consultant, and he's just been in the business forever. You heard his remarks about Steve. He's been around, and his work in New York is just legend. So we're fortunate to have him with us. Please welcome Paul Frederick. Joining Paul today, back by popular demand from our earlier presentation, Claire Robinett, attorney with Hagwood in Tipton. Ladies and gentlemen, please welcome Claire back to the podium. Take it away, guys.
All right, thank you very much. So our presentation is basically from a lawsuit standpoint and litigation. Says on it. I want to put battery.
You gotta go really close to it. Yeah.
No. Can I power?
Yeah,
I
you
think
can.
the battery might have ran out.
Yeah, hold on.
Hello.
There we go.
So we're hopefully going to give you all some tips and clues on if you get sued, and you will, if you're in the hotel or restaurant business. You can't stop that from happening. We've heard that many times today. You can't stop someone from initiating a litigation against your firm or company. But if you do get sued, what are the different ploys that plaintiffs, attorneys use to try and get the large purse and whoever is holding the most money or the insurance policies involved in the lawsuit? And from a safety and security standpoint and a loss control standpoint, what things can you implement within your own companies to assist in supporting that litigation on the positive side to defending that litigation? So preventative measures on the front end with your hotels, with your restaurants, and hopefully we'll accomplish that in our short presentation here. So in the hotel world, and I believe this is the same in the restaurant world, there's major groups of representation that have risks involved in litigation. The first one is investor or ownership groups. There's many companies that, whether they're venture capitalists or investment firms, that say, hey, we think there's a good market in buying 20 hotels this week, or there's a good market in buying 20 Chick-fil-A's, and maybe in 5 years we're going to sell them off when they're high and make a lot of money. But we don't know how to operate them, or we don't know how to what the franchise rules are. We're going to make this investment. So that's one risk right there, is when you make that statement and say, we're going to make the investment, you're now a potential party in a lawsuit. And then the next risk is the management companies. So that owner has to find someone to operate their businesses. And there's companies out there, especially in the hotel world, that's all they do, is they're purely management companies. They don't own the real estate, they don't want to own the real estate. They will go in and make a deal with the owner to professionally operate their hotel, hopefully at a profit. And those management companies, and you'll see in our presentation, make a lot of decisions that guide their employees and guide the safety and security of their guests that automatically bring them into litigation also. The third people that are involved is the insurance companies. The insurance companies are the ones that hold the purse strings to help represent you when you do get into a lawsuit and litigation, and they want to make sure that there's a benefit to them risking giving you an insurance policy, that you're going to do everything you can to prevent unforeseeable acts and to make sure that you're following reasonable and acceptable safety and security practices in your hotels and restaurants. And then the last is the franchisor. So in the hotel business, a company like Marriott or Intercontinental will sell their brand names to a company and just accept a franchise fee. And I think legally, they make up contracts that try and stay at an arm's length from a liability standpoint and put most of the liability on the operator or the franchisee. And we're going to discuss that a little bit and share some real-life litigation outcomes and how you can help prevent those issues also. Oh, sorry. Claire, you want to take the slide?
All right, y'all hear me?
See, now you're not.
It was working. Hello?
They go to sleep if you don't.
Hello, hello.
Right, as soon as I get to the front.
Just want to make Stephen move around. So I'm going to be talking about risks, and I'm going to talk about ownership risks and then your management company risks. Obviously, in the ownership sense, the innkeeper has the ultimate duty of care to their guests, and that is a heightened duty to guests that are paying to be on premises. The perfect scenario would be the absentee landlord, because yes, they're still considered the owner, but they're not quite deemed to be in control of the premises enough to have liability imputed to them. As we can all imagine, the more the merrier in litigation, and that is why when a plaintiff files suits, they're going to include, anyone and everyone they can. And that usually includes the owners as well as the management company. I'll take a wild guess, or would anybody take a wild guess of why an owner is included in addition to the management company? Money? Notoriety? Name? What's that? Insurance. Yeah, insurance. Usually the insurance has the most money. So yeah, and that's an even more important reason why co-defendants or smart co-defendants will create a unified front for their defense. You are just making it easy on the plaintiff if you start tearing down your co-defendants, and you're just easy pickings. Another thing is the innkeeper, the owner, can never fully delegate the ultimate duty of care. So the better definition of that I like to say is the premises controller. And that is the one that is in control of the premises, maintains, supervises, ensures safety, in all aspects. And is a completely different person from the absentee landlord. How else can we keep an owner in suit? Well, sometimes if the plaintiff is able to establish that an owner was on notice of certain safety conditions and failed to remedy those conditions, something bad happens, then that's an excellent way to keep somebody in who owns the property. You'll hear about parties getting released. Usually, the danger of that is parties start dropping like flies, and then you've got empty chairs at trial, and a jury is looking at one company, one entity, one person to hold responsible for negligent conduct, and those empty chairs have either settled out, been dismissed, or are no longer players. So, be wary of those situations. All right, management companies. As you know, this is the target defendant. These are the entities that are contractually obligated to ensure the safety of premises. In the aspect of co-employment, co-employees, there is some concerns because, one, if your management firms are broadly encompassing, all of the duties and conditions, then they're broadly encompassing all of the risk in litigation as well. I'm sure y'all have heard of Pearson Corporate Vale and shell companies, and there is a benefit, of course, to doing, co-employment, where those duties can be set out in such a delicate way that they don't necessarily overlap. But the overall goal is achieved through finite rules and limitations to any kind of responsibilities, so that your management firm or your management company hasn't accidentally taken over too much, and it's certainly the only one on the hook.
Let me just ask a quick question there. Especially now after COVID, in the hotel industry, and probably in other industries also, it's a hard time getting staff. I mean, hotels are understaffed. They can't find people that want to come to work. So, in turn, to provide services to the guests, they have to hire contract labor, and that's been going on for a long time, but it's more prevalent now because of COVID. But I never see in litigation the plaintiff trying to go after the contract labor company. They always go after the management company that hired the contract labor company.
Right, and usually the advantage of that is in the contract agreement itself. If there are management exclusions to the contract where the management company is on the hook and agrees to indemnify, then it becomes more advantageous for the plaintiff to go after the management company.
And it might be a deep pocket thing. The contract labor company probably doesn't have as much money as the management company.
Right, that's money.
Okay, so we're going to talk about a couple cases here, and we'll discuss what happened with the case, and then get Claire's legal opinion on why she thinks it went the way it did, just from a settlement standpoint. So this was a case, Marchianda versus John Q. Hammond's Management Company. It happened in 2014. It was settled in 2019 for an undisclosed amount. But this was a Embassy Suites franchise, which Embassy Suites is a brand of Hilton. John Q. Hammond's is a big management company, and probably 80% of their hotels that they manage are Embassy Suites, or were Embassy Suites when they were a prevalent company. And then this hotel was owned by another entity called Atrium TRS. So I'll give you just a little background of this case if you don't know it, and then we'll tell you who was sued, and I'm interested to hear why you think. So this was a case where a business woman traveler was staying at the hotel. She went to her room, drew the deadbolt, drew the night latch, put the do not disturb sign on the door, and a colleague of hers who knew that she was staying there, who stayed in the hotel every week for a long period of time and knew all the hotel staff, knew the front office manager, knew the chief engineer, knew the general manager. I mean, he was always there. He was almost living in the hotel. But this woman was just there for a week for a conference for the same company. And I'm not 100% sure if they worked for the same company or not. But he was able to, this offender was able to convince the chief engineer that he needed to check the welfare of this woman in the middle of the night, and convince the chief engineer to open the door with his emergency electronic key and to cut the night latch that she had engaged also. And then the engineer just left, and this gentleman assaulted this woman. Those are the facts of the case. What I found interesting is that the franchisor, Hilton, was never brought into the case. Only the management company and the owner. And I would think, especially with a big name like Hilton, why they didn't bring in the owner. And what do you think the strategy there was from the plaintiff?
Sure. So the court held that the owner of the hotel, this was Atrium, was the franchisee because the actual owner was a subsidiary group who had leased it to the franchisee under the FLA, the franchising licensing agreement. There were two agreements entered into. The first one, the FLA, was held to control because it was signed first. The first FLA contract, they control the premises. Obviously, if anything happens, we'll indemnify you. The second management agreement took over the exact same duties, but again, was signed at a later date. So when the dispute came down to which contract would control, the first contract did control. So in this instance, Humans, the management company, was actually bankrupt. Atrium was the actual franchisee, who was considered to be, the owner was considered to be the franchisee and ended up taking the brunt of the judgment being on the hook for liability.
So this must have been, I think, a decision from the plaintiff that they saw how the FLA was written.
True. If they had been provided copies of it, and I know they have, then the smart attorney's going to go up to one with deeper pockets and figure out how the contract controls and with who, with party.
Okay, great. So, as far as insurance exposure, when plaintiff attorneys are looking at suing a hotel company or a restaurant, one of the first things they do is they look at what's the experience that they've had from a loss standpoint, and who insures them, and what are the caps of liability, or look at the certificate of the limits. Every attorney I ever worked for on the expert witness side, they say the first thing they do is pull the insurance certificate and find out what are the limits, because they want to know who has the deep pockets.
Was Hammonds self-insured?
I don't know the answer to that. That makes a difference too. Yeah, that's a good point. I don't think so. I think they were represented by an insurance company. The insurance company exposure also is going to pay for the legal fees. So that's why they're at risk when there's a lawsuit. And a lot of insurance companies, unless it's pre-written into the agreement with the insurance company, they're going to take ownership and control of the litigation. They want to be the ones controlling what law firms get hired to represent them, how the money is spent, what experts are used. But some hotel companies are successful at negotiating that up front at the insurance side, especially ones that have their own in-house counsel and their own litigation teams. And then impact from litigation for insurance companies is when you get big verdicts, like the ones that we're going to share with you, it's going to max out several layers of different insurance policies to pay for that verdict. And in reality, that may mean that the hotel company that lost that case is gonna have to look for a new insurance company the next renewal cycle, because insurance companies look at your experience, your loss experience, and how much money they've had to pay out against claims that they're helping you represent. All right, Frank, I promise I'm not picking on Hilton. But there's a couple Hilton lawyers in the room, so I
I swear,
apologize.
we didn't slash your car's tires.
Good thing I didn't drive here today, right? But the second case that we wanted to bring up was in Houston, Texas. This just recently was a verdict, and it was a jury award of $44 million. And I still scratch my head over the way that this ended, because it's a situation where really the hotel was just trying to do the right thing, and they ended up having to pay on this one. But it was at the Hilton Houston Americas. The Hilton Houston Americas was managed by Hilton Hotel, or Hilton Worldwide management company, but it was owned by the city of Houston. The hotel was owned by the city of Houston under a company called Houston First Corporation. It's connected with their convention center, and when they built the new convention center, they built this hotel, decided to brand it a Hilton and hire Hilton to manage it for them. And in this situation, the city was not brought into the litigation, nor was the police department. And the police department responded to the incident. So this incident, just the facts of the case, was that a female guest went outside the hotel, had drinks outside the hotel, and became inebriated at another establishment, took an Uber back to the hotel, but when she got out of her Uber, she passed out on the sidewalk adjacent to the hotel. So passerbyers had called 911, the police show up, and there was a gentleman standing next to her and telling the police that he knew her and he was trying to provide aid to her. And the police went in and got employees of the hotel to come out and help also, because they were trying to figure out, you know, who was who. And this gentleman convinced both the police and the hotel staff that she was with him. They put her in a wheelchair and he rolled her up to his guest room. He was staying in the hotel also, and he sexually assaulted her in his guest room. And I think the verdict, pretty much the judge summary for the case said that he felt Hilton didn't do provide a duty of care to her to figure out if she was a guest where her room was, and didn't give her safe harbor in her own guest room, instead of just handing her over to this gentleman who just verbally said, "Oh yeah, I know her, I'll take care of her."
That's exactly right. And this is not the run-of-the-mill premises case. In fact, this plaintiff was pretty savvy in crafting his complaint, because he didn't gear it as a failure to secure the premises. He geared it as a negligent conduct by the employees. That negligent conduct was their failure to verify her identity when they discovered her. And I believe they walked them both up to his hotel room. So while they may have believed what he said and verified who he was, you still got a technically unidentified woman who they handed to the assailant on a silver platter. You brought up a point about, I wonder why, the city or the police department, what role they had. I represent some municipalities, and the larger municipalities tend to be insured separately. So they are not under the larger pots that many outlying counties would be privy to. So my guess is City of Houston, I bet a lot of people sue the City of Houston, or Houston Police, law enforcement. And, they realized that deeper pockets would definitely be with the hotel. Again, that's just a running thing.
Do you know, Stephen, in Houston, is there a law that you can only sue the city for X amount of dollars, or?
Well, you got your general tort claims.
Yeah.
Limitations, so that could have been a notice issue, maybe they ran afoul of that. But, yeah, I'm not all that familiar with this case, even though I have in my own backyard, but, yeah, but that would be my thought, Claire, I don't know.
Right, and what was kind of, still, the whole thing's egregious, but, I believe that the Hilton employees and the police officers, when they found this woman, that the assailant was already with her, and highly suspicious activity at that point, he has either his pants down or unzipped or something like that. It's, the facts were, horrific. So, again, this was a case where they were looking to the insurance company for the deep pockets.
Now, let's get into franchisor responsibility a little bit. So, companies that franchise out their name, even though they try and keep it at arm's length, do have a responsibility to their brand and their franchisees to help them provide a safe place for their patrons to go. And how they do that, both in the restaurant business and the hotel business, is to create brand standards and guidelines. But uniquely, at least on the hotel side, most brand standards and guidelines are for non-safety and security issues. They're how to fold the towels, what kind of toilet paper to buy, what kind of soap and shampoo to have in the room. Now, it will say in a brand standard that you have to have safety and security procedures, you have to have an emergency manual, your employees have to be CPR certified, but it never says how to do it, or they don't give you a manual to say, here's what you have to, the steps to follow. They want you to do that yourself, so they keep an arm's length on the litigation. So that's the distance with the franchisee. And then there's a level of the policy enforcement. If you have these brand standards, who's going around and checking to make sure that you're following them? Most hotel companies use a quality assurance process and send out auditors once or twice a year to check that you're complying with all the brand standards. But on the safety and security side, that might not be the case. So it takes your independent risk managers or operations people when you're a franchisee to make sure that your safety and security standards are being followed. Because someone from the brand, like I said, is only going to check that you're folding the towels properly, or when you walk into the lobby, everything is, the furniture is set the right way for the brand image. And then the last thing, as far as exposure for the franchisor, obviously, is reputation. And that's becoming bigger and bigger in this industry. And I think all the major brands have realized that on the hotel side and on the restaurant side, in the food service side, is there used to be a long time ago this thought from general counsels that, hey, don't get involved from giving any advice to the franchises. If they have a problem, they need to work it out themselves. We don't want to get involved, but that's evolved over the years, and it really supports the reputational risk part of litigation. So here's a restaurant case. You might not know it by the name, but Anna Aaliyah was the one who, back in the news in 2005, claimed that she found a human finger in her chili at a Wendy's restaurant. And And this hit the news all over the place. And it came out that in the investigation and through discovery that she was a fraud, that she had filed 13 other claims against other restaurant chains. And so Wendy's stood up and did the right thing, and they sued her. And they got a demand of $21 million. I don't know if they've ever collected or were able to collect, but I think it set a good precedent and stance that when you do get a fraudulent lawsuit, that you should take a stand and take it all the way through.
Absolutely. And I have clients that, you know, weigh the cost versus benefit of pursuing a case. And I think that's always in the back of your mind. But at some point, you know, it's going to get out that this client or this firm always settles out. And the important thing is to push back. And, you know, Wendy's did that in this case. I believe the facts of the case are super interesting. She claims that, you know, she was eating her chili and, you know, she bit down on a severed finger and reported it to staff, and, you know, nobody knew that anything had occurred. You know, employees of Wendy's were deposed and nobody had lost a finger lately, so I think that's something that we noticed. The forensics that they ran on the finger, I think it was determined that she had boiled it or something, and it just didn't match up to what the chili's recipe and internal temp for 3 hours at 170, you know, yada yada. None of it made sense. So they start, you know, digging, and I think the incident occurred maybe mid-March, and then 2 weeks later, in April, suddenly she abandons her claims for compensation against Wendy's, and additional facts come to light, like for 13 prior civil claims. We realize that she's settling out before these matters can go to court. She is, I believe, what the court, what do they call her, recreational litigant?
Yes.
So this was her job. She was a career plaintiff. It turns out her husband is the one who had located the finger, and they had, you know, concocted the scheme, and they both went to jail 9 years, and Wendy's was awarded 22 in restitution, and I doubt that they ever saw it, but the reason that, you know, it's important we're talking about it right now. We're talking about why Wendy's fought back, and the importance of sometimes risk versus benefits of litigation.
So we just have a short time because we're running a little short, so I'm going to skip over some things. But the important things when that attorneys, that always plaintiffs ask for in discovery is contracts. They always want to see the contract, who they feel is legally responsible so they can go after the right party. Indemnity clauses, hold harmlesses, a regular review of claims, and loss control prevention reviews. They will ask for all of these things in the litigation from a discovery standpoint. Did you have anything you wanted to add to that?
Just, you know, the importance of carefully crafted contracts and indemnity clauses can save you millions down the road. So short and sweet.
I'm going to skip over this case because this is a pretty famous case, the Aaron Andrews case, and it was a high dollar award, $55 million. And it was interesting, again here, even though Marriott International was dismissed from the litigation and did not pay a dime to this award, whenever anybody in the industry says the Aaron Andrews case, they always say, oh yeah, that was at the Marriott, but it was a Marriott franchise. It wasn't Marriott corporate. And then from a safety and security standpoint and just a prevention standpoint, you know, we just want to drill down that if you do proper education from your line level all the way to your managers at the property level. Almost every lawsuit that we see that gets blown into litigation started with a small thing at the property. And sometimes it was just a small noise complaint. I had a case where a gentleman called the front desk and asked for them to come up because he heard some fighting in the corridor. And it took the front desk person 2 minutes to have security go up, but the gentleman in the room couldn't wait that long. And he went out in the corridor and got in a physical altercation with the people and ended up getting beat up pretty bad. And but as far as education and prevention, it's important to make sure that you have procedures within your own company, whether you're a franchisee or whether you're a management company, on how to handle situations at the property level, because that's who's handling it right when the issue happens. Compliance with brand standards, make sure that everybody on your property knows what the brand standards are and what the quality assurance teams are going to look at. And don't disregard brand standards because you don't have the money right now, because that comes up in litigation all the time also. Why didn't you comply with this brand standard? It's been a brand standard for 10 years. It's important from a safety and security standpoint to locally have liaison with your law enforcement and fire officials, because you can resolve a lot of things locally and informally without ending up to take it to litigation. And regular loss run reviews is very important, especially on the insurance side, because even if you're having small losses, small slip and falls, small thefts out of guest rooms, 10 of those small ones are going to lead to a big one. So there has to be someone responsible within your organization to identify those and figure out how you're going to mitigate it against them. And that's it. Any questions?
Good stuff. Thank you.